Paula Gerber. I'm one of the Deputy Directors of the Castan Centre, and it's one of my great privileges to chair this session this afternoon. I think you'll all agree we've had a very interesting and stimulating morning, and I have no doubt that that is going to continue into the afternoon. Our first speaker today is Professor Tim McCormack. I was a student in Tim's IHL class over a decade ago now, and have been a big fan of his ever since. And we're chatting earlier about how topical and current IHL is these days, and that you can't go a day without it being reported somewhere in the media that an issue related to IHL. So it's great to see that it's getting the profile. Unfortunately, a lot of the time it lacks the depth of analysis that we'd like to see, but Tim's certainly going to remedy that this afternoon in his session, when he's going to be talking about the current caseload of the ICC and discuss the prospect of the court's potential to increase respect for IHL, because it certainly is one of those areas where there is a perception, at least, that it is observed more in the breach than in the respect. I'm sure Tim is one of those people who, it's a bit of a cliche, but a true one in this instance, needs no introduction. He is well known and well respected by many people. I'm sure most of you here, but if there is some alien who doesn't know who Tim is, then I'll say a few words about him. He is, of course, a Professor of Law at Melbourne Law School and the Special Advisor on International Humanitarian Law to the Prosecutor of the ICC in The Hague. He has been involved in many of the most high-profile IHL matters, including in the Slobodan Milosevic case in The Hague from 2002 to 2006, and he also provided expert law of war advice to Major Mori, who we all saw on a regular basis in the media in relation to the defence of David Hicks in the proceedings in the US Military Commission. So please join me in welcoming Tim.
Thanks very much, Paula. If we were in Tasmania, where I come from, you'd all be cousins of mine, but perhaps it's and I'm allowed to make those jokes and you're not. Perhaps it's a good thing that's not the case. But let me just say, before I launch into the substance of today's presentation, that it's always special for me to participate in any Castan Centre event, because the centre is named in honour of a truly great Australian, Ron Castan. And my relationship with Ron, I treasure deeply. Every memory of my interaction with him was very, very special. It was a tragic loss of his life to be cut short prematurely, and I think it's a wonderful thing to honour his memory with the establishment of the centre. I wasn't asked to give a eulogy, and I don't propose to do that, but I will just say that I will seize every public opportunity afforded to me to acknowledge and honour his memory. So thanks to Sarah and others at the Centre for the opportunity to participate today. And this is a topic very close to my heart, the International Criminal Court, the other ICC. My appointment as Special Advisor to the Prosecutor was announced in the news in brief in the Melbourne papers on the same day that former Prime Minister John Howard's nomination as Vice President of the other ICC, or perhaps I should say the ICC, was reported in extensive detail in the Melbourne press. I didn't really take that too personally. I understood that there was more interest in a popular sense in the other nomination, but perhaps I should just say I'm still advising the prosecutor. All right, I won't even say it then, okay. It seems to me that 10th anniversaries give us an opportunity to pause and reflect, and the ICC I'm talking about is in the midst of 10th anniversaries. In 2008, we in the international community marked the 10th anniversary of the opening for signature of the Rome Statute, which happened on the 17th of July 1998. We're now moving towards the 10th anniversary of entry into force of the Rome Statute, an anniversary that will be marked on the 1st of July 2012. So we're in a period where it's opportune to reflect on what's been achieved and what still needs to happen. And I think it's fair enough to be able to do that. And perhaps what I would like to do first up is start with some criticisms that have been levelled at the International Criminal Court and respond to those, and then maybe talk about some of the achievements, and particularly the one reflected in the title of today's talk that Paul has alluded to. First criticism is that 10 years without a single concluded case isn't good enough. And I have to concede that there is some merit to that criticism. It's important, though, to clarify that we're not talking about 10 years of operation of the court yet. Whoops, don't put too much weight on that. The fact is that the court itself, after entry into force on the 1st of July 2002, was only established in March 2003 with the election and swearing in of the first 18 judges, the prosecutor and deputy prosecutor, and the registrar and the deputy registrar. And by the 10th anniversary of the establishment of the court in 2013, there will be 3 or 4 cases concluded. Right now, the court is focused on the conclusion of the very first trial at the ICC, which is the case against Thomas Lubanga, a militia leader of a non-state armed group in the Congolese conflict. The closing submissions have already, the written closing submissions have already been filed in the case. The prosecution's early in June. The defence response just a couple of weeks ago. Prosecution now has the opportunity for a final rejoinder to the defence submissions, and the oral closing submissions are scheduled for the last week in August. And the expectation is that the judges of the trial chamber will deliver their first judgment in the court's history in the Lubanga case before close of business in 2011. That is a welcome development. It's taken longer perhaps than it should have done, and it's really important that now finally the ICC gets up and running in terms of its caseload, and it concludes some trials and that begins to develop its own body of jurisprudence. So the Lubanga case will be followed in 2012 by the judgment in the Katanga and Ngojolo case, also a Congolese-related case, the trial of Jean-Pierre Bemba, the first trial in the Central African Republic, and also presumably conclusion to the first Darfur case against the rebel leaders Banda and Jerbo, who are accused of an attack on the African Union mission, or a contingent of the African Union peacekeeping mission in Darfur. This case is remarkable for the fact that having issued, after the pre-trial chamber issued the arrest warrants against Banda and Jerbo and also Abu Ghada, the leader of the rebel movement, the 3 of them turned up in the Hague and voluntarily surrendered themselves. This is an extraordinary thing. We don't expect that sort of thing to happen. As a consequence, the prosecution did not seek to have them arrested and detained. And there was no reason to apply for bail. They come and go every time hearings are scheduled, and so far they haven't missed a single beat. Remarkable. All right, so there is a valid criticism about the court taking too long to get up and going, and finally I think it's starting to hit its straps in relation to the trials being concluded. That's a positive thing. A second criticism is that the court is African-centric. All the cases so far are dealing with African conflicts. It looks like it's some sort of neo-colonialism as the international community establishes this multilateral court, but all it deals with are conflicts in Africa. The criticism has some merit. It is important that the court is seen as being more concerned just than with African conflicts, but I also think the criticism is overreaching, is unfounded to some extent. The reality is that in 3 cases involving the Democratic Republic of the Congo, Uganda and the Central African Republic, all 3 governments self-referred their situations to the court and asked for the ICC to assist them. They all said the civil war that has racked our country is too difficult for us to deal with in terms of the justice issues. Please assist us. The ICC was set up, this ICC, was set up to help countries deal with their justice challenges in circumstances where they were unwilling or genuinely unable to deal with them themselves. So there is a sense in which, at least in those 3 situations, the ICC is doing exactly what it was established to do. And it's an unfair criticism to say that those three countries, all having come from Africa, somehow or other taint the court in an African-centric approach. Then we also have the case of Côte d'Ivoire, the Ivory Coast, which is not a state party to the Rome Statute, but which in 2003 accepted by declaration the jurisdiction of the court ad hoc. And that declaration, lodged in 2003, was affirmed last year by the government in the Ivory Coast to be still valid, to be continuingly valid. And on the basis of that, the prosecutor has commenced his investigation into the violence in the Ivory Coast. So again, it's a case that's come to the court by way of the government's own choice. There are two other situations in Africa referred to the court by the United Nations Security Council: the Darfur region of Sudan in 2005, and of course, more dramatically perhaps this year, the Libyan situation. Again, the Security Council has referred the cases to the court and wants to use the court to deal with them. And I think it's unfair to criticise the court itself that all the conflicts are from Africa. Perhaps you could say, in fact, that Libya is a refreshing break from sub-Saharan African conflicts, even though, of course, it lies geographically in the north of Africa. Only one of 7 situations before the court, situation of Kenya, has come to the court by way of the prosecutor acting on his own initiative, an authority that he has under the statute, and that is in response to the pre- and post-election violence in Kenya, where over 2,000 civilians were killed. It is, I think, still a challenge for the court to break out of the African continent to be able to deal with conflicts outside of that region. And sooner or later, I'm confident, I'm not alluding to inside information I've got that I can't pass on. I am confident that there will be a situation where the court has jurisdiction and is able to deal with the case, and that will be a welcome development because it will counter this perspective, this perception that exists. A third criticism is that the ICC keeps on, or at least the prosecutor, keeps on issuing indictments that he knows he can't actually do anything about because he's not going to be able to get physical custody of the accused. This is a criticism made particularly in relation to the President of Sudan, Omar al-Bashir, and also now in relation to Muammar Gaddafi and his son and his military commander al-Senussi, the subjects of the most recent arrest warrants. Well, this is a criticism I reject because I think that we could have said exactly the same thing in relation to the prosecutor of the Yugoslav tribunal back in the 1990s, issuing arrest warrants against Slobodan Milosevic, Radovan Karadzic and Ratko Mladic. At the time that the arrest warrants were issued against those 3 individual accused, there was no prospect of any of them being brought into custody. Milosevic was well entrenched in power in Belgrade. Karadzic and Mladic were entrenched in power in the Bosnian Serb Republic. And even when there was a transition of political rule in the Bosnian Serb Republic, they had huge support, domestic support. And the prospect of any of them being transferred to The Hague seemed so remote. Well, my argument about Omar al-Bashir is that things can change on the ground, and there is no statute of limitations that applies to the alleged crimes against humanity or war crimes or even acts of genocide that his government is accused of perpetrating on the minority groups. And at some stage in the future, if the political landscape shifts in Sudan, it may well be the case that he is brought into custody and transferred to The Hague. So I don't accept that criticism. I think that sometimes it might take years, sometimes it might even take decades, but the fact is that those arrest warrants will stay valid, and Omar al-Bashir already has to be careful where he travels. Most recent country to advise him not to come was Malaysia, yet to become a state party to the Rome Statute. But the Malaysian government announced just a few months ago that because it plans to become a party to the Rome Statute, it didn't want the embarrassment of Omar al-Bashir in its country and the possibility of him being arrested there. So don't come. I think that's actually a positive development from my perspective if his travel options are limited while the arrest warrants are valid against him. What about some achievements then in 10 years of operation? Well, the popular view of international humanitarian law is that it is toothless. It is honoured in the breach more than in its acceptance. And it seems to me that the single greatest contribution to countering that perception is the dramatic developments in the last, now 18 years of the establishment and, it seems, proliferation of international criminal courts and tribunals. Commenced with the Security Council's decision to establish the Yugoslav Tribunal in 1993, the following year the Rwandan Tribunal in 1994, the negotiation of the Rome Statute in 1998, and then it's almost as if it's hard to put the brakes on with the establishment of the Special Court for Sierra Leone, the Extraordinary Criminal Chambers for Cambodia, the Serious Crimes Unit in East Timor, the Special Tribunal for Lebanon. And it's not just a proliferation of international criminal courts and tribunals, but a huge increase in domestic prosecutions and proceedings. Pinochet is a classic example of this. He wasn't actually tried in the United Kingdom. You'd be forgiven for thinking that he must have been because there was so much media attention. It was all about whether or not he could be extradited to Spain to face trial there. And that case, I think, really in the environment of this increasing institutional building that was going on, raised expectations around the world that accountability for atrocity is something that is desirable, that we should push for, and that perhaps is now much more attainable than at any earlier stage. It seems to me that that is actually a contribution, a very significant contribution that the ICC has already made, not solely, not on its own, irrespective of other international criminal courts and tribunals or other developments at the national level, but a really big part of a global phenomenon which is having a positive flow-on effect. I'd go further actually than just talk about the raising of expectations, but also to argue that the establishment of the ICC provided a catalyst, a very important catalyst, for radical domestic criminal law reform. Australia was not immune from this phenomenon. Our new Division 268 of the Criminal Code Act, which incorporates all the crimes in the Rome Statute, all the separate acts constituting genocide, all the separate acts constituting crimes against humanity, all the separate acts constituting war crimes in either an international or a non-international armed conflict, have now become part of Australia's domestic criminal law. Prosecutable, incidentally, in Australian courts on the basis of universal jurisdiction. That is, in relation to alleged crimes wherever they've occurred in the world, irrespective of the nationality of the perpetrator and irrespective of the nationality of the victims. The legislation, our International Criminal Court Consequential Amendments Act, which added Division 268 to the Criminal Code, is not retrospective. It applies only to acts occurring after the 1st of July 2002, the date Australia ratified the Rome Statute and also the date that our legislation became operative. But importantly, from that date on, we have a dramatic revolution, bloodless it is, in our domestic criminal law. The motivation for the legislation, you could argue, was ignoble rather than a noble, principled one, because the Australian government wanted to ensure that it could benefit from the so-called complementarity formula in the Rome Statute, that the ICC is only a court of last resort, that it complements national courts, it doesn't override national jurisdiction, and that national jurisdiction is primary for either the territorial state, the state on whose physical territory the alleged crime occurred, or the state of nationality, the state whose national allegedly perpetrated this offence. Either of those states has a better claim to jurisdiction than the International Criminal Court itself. All right, so from an Australian government perspective, let's make sure every single crime in the Rome Statute is part of our domestic criminal law, so that at no stage in the future where we might want to exercise national jurisdiction, it would be possible for the ICC to say Australia is genuinely unable in these circumstances to exercise its primary jurisdiction. I'm not singling Australia out as the bad guy here. Heaps of countries have done this. States parties and non-states parties to the Rome Statute. So the ICC, just by being created, had a very significant impact on domestic criminal law. The question really, I suppose, is whether it's done more than that. Whether it's enough to just say, to claim this as a great achievement. The best legislation in the world doesn't necessarily guarantee that it will be utilised, of course. So has the ICC created or constituted an added incentive for states to take more seriously the domestic enforcement of international criminal law? I would argue yes, and that we have seen examples of that already. Sometimes that incentive is a contrived one, as was the case in my view by the journalist in The Australian, who claimed that the motivation for laying charges against 2 Australian Defence Force members in Afghanistan was to avoid the International Criminal Court taking that case on. That was a complete misrepresentation, in my view. It wasn't even that someone had to hack a phone to get that story. I think the story probably went along the lines of the journalist ringing public relations in The Hague at the International Criminal Court. I understand from your website that there has been a preliminary inquiry by the prosecutor into the situation in Afghanistan. Is that correct? Yes, that's correct. If there was a case of civilians being killed by Australian Defence Force members that wasn't prosecuted in this country, would the ICC be interested? Yes, of course the ICC would be interested. Would the prosecutor look at that? Probably would look at that. Thanks very much. And then the story becomes what it becomes. So it's possible to, the argument I'm making here is it possible to contrive the incentive that the existence of the ICC represents for national prosecution of international crimes. But there are other situations where it's clearly not contrived. And one example, perhaps the best one that I'm aware of, is the Israeli Supreme Court finding 2 members of the Israel Defence Force guilty of the war crime of using a Palestinian child to open a bag which may contain an improvised explosive device. Some of you will know the case. It was just a few months ago. Those 2 soldiers were convicted of war crimes by the Israeli Supreme Court, and there was great consternation in Israeli society by some sections of Israeli society that saw this as an attempt to make sure that the Goldstone report didn't cover a case like this, that Israel was able to deal with it themselves. My argument generally is that if this is one of the consequences of the ICC being in existence, thanks Paula, then it is having a desirable effect, because states, if they are taking more seriously their national primary jurisdiction, that is a good thing. The fact is there are too many allegations of the law of armed conflict or international humanitarian law going on in the world for the ICC to be able to deal with them. It's fundamental to the effectiveness of this new international criminal justice system that there is also robust national prosecutions. Okay, I would say that the ICC is already having a significant contribution, although it's really important that it starts to get its case law building up and that it becomes known as an effective court. After all, if it never ever dealt with any trials, we would eventually say, well, enough of the catalyst for states to get their acts together. The ICC is a lame duck. That's not going to be the case, and the next few years, I think, will be the start of very significant trial development. So having come to that positive note, let me just end with a word of caution, though. And here I think there is still a very, very big challenge for the international community. I am an unashamed advocate for and supporter of the International Criminal Court as an institution, but I don't believe that it is a panacea for all the ills of the world. It is a huge step, from my perspective, in the right direction of challenging impunity for atrocity, of trying to develop more systematic accountability for those responsible for egregious international crimes. But to suggest that somehow or other it represents a comprehensive, systematic institution applying impartial justice is, of course, a misrepresentation. The International Criminal Court has some very significant limitations to the exercise of its jurisdiction. And we can point to Libya and to Syria and contrast them and say, why isn't the UN Security Council prepared to refer the Syrian situation to the ICC? Why isn't the UN Security Council prepared to refer the Sri Lankan situation to the ICC? How much more evidence of allegations of violations of law of armed conflict in the last few months of the Sri Lankan civil war do you need? There are some serious limitations, and anybody like me who believes in the project that is underway at the multilateral level for international criminal justice must accept that the single greatest challenge is the lack of a systematic, comprehensive, impartial system. We have to keep working on that. I think if you look at the last 20 years, you see that we've made some steps in the right direction, but there's a lot more work to be done. So no rest for you if you thought it was going to be cushy. Thanks very much.